Good morning. One and all, good morning and welcome to this, the final, but of course the best day of the Federalist Society's 35th Annual National Lawyers Convention. If you're only here for one day, you've chosen the best day. Yesterday was... Susan, that's not right. Yesterday was pretty good, but today we have two showcase panels. This is the only day of the convention with two showcase panels. We have three breakout sessions, the Rosencrantz debate, and the closing session with the Scalia Speaks book, with the book signing. I'm very excited and pleased to welcome you this morning. I've already mentioned the record crowds we've had this year, but it's not only been a good crowd, but an enthusiastic and lively crowd. And I'm not talking about the people yesterday who tried to disrupt the proceedings during EPA Administrator Scott Pruitt's interview. That's too enthusiastic and too lively. But I'm talking about your social media engagement, which I'm told by our staff has been spectacular. Our digital staff reported to me this morning that yesterday on Twitter, we were triple trending for the first time ever. So I must have had a look of concern on my face when they told me that, because they said quickly, that's a good thing. And if you'd like more information on what triple trending on Twitter means, that's hard to say, just please ask somebody younger than me and they'll fill you in. But well done to all of you. Now, this morning, of course, we begin our showcase panel on the administrative state in the executive branch. And I'm pleased to introduce you to our moderator, Judge David Barron of the First Circuit. Is this your first appearance as a judge at our convention, maybe?
It might be, yeah.
Might be. So he graduated...
Hopefully not my last.
No. Well, we'll see. No pressure.
I guess it will be my last.
No pressure, Judge. He graduated magna cum laude from both Harvard College and Harvard Law School. He went on to become a tenured professor at the law school. Having left law school to become a judge, it strikes me now that we could have a discussion on moving from a tenured position at a law school to moving to a different sort of tenure, lifetime tenure on the bench, which is better and why. That might be an interesting discussion. I would note that I suppose my first thought is there's no good behavior requirement or limitation on professors, as there is with judges. So. Judge Barron, of course, not just a judge and a professor, he also served with distinction in the U.S. Department of Justice, where he ran the Office of Legal Counsel for some time. So he comes to us today with special insight into our topic, our real panel topic, the administrative state in the executive branch. I also note that Judge Barron was born right here in the District of Columbia. So, Judge Barron, welcome home.
Thank you for the introduction and for inviting me to come here. I would describe this as sort of a shocking crowd given the topic and the time of morning. Having taught administrative law, I always tried to schedule it in the afternoon and certainly never on a Saturday. So I'm impressed that so many of you are here. The topic today is the executive branch and the regulatory state. And just to frame it, the way I used to teach administrative law, to introduce the students to it, you would try and integrate the administrative state into the constitutional structure. At least I did it in the following way. There are three different actors who constitutionally have to exercise control over the administrative state. There's the Congress, which obviously exercised that control by creating the agencies, but then also by checking them through appropriations and subsequent statutes that can countermand what they've done, and also by exercising oversight over them and by regulating the appointment process through the advice and consent of the Senate. There's the judiciary, which regulates them on the back end by reviewing the products that they put out, oftentimes pursuant to statutory standards, such as set forth in the Administrative Procedure Act, but also occasionally pursuant to constitutional standards. And then finally, there's the executive in the form of the president, who also has to exercise some control over the administrative state. And there's all kinds of questions about how can the president do that given the imperatives of those other two branches also having authority to control. To what extent can the president direct what agencies do? To what extent does the president have to respect the fact that Congress may have established the agencies to be at an arm's length distance from the president's direct control. And those have been the subject of large debates and shifting positions within the academy, and I'd say within agency debates among people who are more policy-oriented and politically oriented as to how to think about that. And we're at a particular moment where that debate is present again, and we have with us four terrific people to help us think through those issues. So with us today we have Susan Dudley, who's a professor at George Washington's Trachtenberg School of Public Policy, and comes to the issue with direct experience as a former administrator of OIRA, which, as you know, is the entity within the Office of Management and Budget that sits, well, I guess Susan may have a different view of this, sits on top of the various agencies of government and reviews their regulatory product, or at least some of it. We also have with us Aditya Bamzai, who is a professor at University of Virginia Law School and had worked in the executive branch at my old office, the Office of Legal Counsel. To my left is Lisa Heinzerling, who's a professor of law at Georgetown University and comes to us with great experience not only as an environmental scholar of the first rank, but also as a former associate administrator of EPA's Office of Policy and as the senior climate policy counsel for the administrator, both during the Obama administration, and who's written a great deal about the relationship between OIRA and the agencies. And then finally, we have the current administrator of OIRA, Naomi Rao, who in her own right is a scholar of these issues. So with that by way of background, what I've asked the panelists to do is to start us off each with sort of a brief introduction to a piece of the problem. Susan's going to give us a sort of a historical account of the nature of this tension, I think probably with a particular focus on OIRA. Aditya will talk about the general constitutional structure that structures that relationship. And then Lisa and Naomi will give us a more on-the-ground view of the tug-of-war maybe between OIRA and the agencies. Then we'll have a conversation just among the five of us that I'll help moderate, in which we'll maybe broaden it out beyond just the bounds of OIRA and talk about some of the real challenges that arise when you have an administrative state and you've got a president and a White House. How do they relate to one another? And then with 45 minutes or so left in the program, we'll open it up to all of you for questions, and we'll probably bounce back and forth, and any questions the panelists have for each other are most welcome. So with that, Susan.
Thank you very much, Judge Barron, and thanks to the Federalist Society for having me. I've really been enjoying geeking out on my favorite topic these whole 3 days. So I'm not sure I could choose, like Dean, which is the best of the days. But so I actually have, yes, I have some slides that you can see here. So Judge Barron had asked us all to try to keep our opening remarks to 5 minutes, and I'm going to try to do that. Although just this morning he said we could spill over a little bit. So what I have here are pages in the Federal Register. And this is not a perfect measure of regulation, is one of many. There is no perfect measure of regulation, but I like this one because it goes back to 1940. So it goes back even further than I do. I think I'm the person on this panel that is supposed to bring the history and longevity, but I don't even remember 1940. So here are the pages in the Federal Register, and I use this with my students just to talk about some of the key milestones in the administrative state. And of course, I start with the Administrative Procedure Act and talk to them about what that means and what it did. But then I also ask them about that period from, if you can see, it's 1970 or around 1970 to 1980, and I ask them what do they think was going on there. You see that rapid increase in regulatory activity. And I get some very creative responses, but including some that are true. But what I almost never get is that was a period of deregulation, when in fact it was. It was from the mid-70s to the mid-80s that President Carter and Reagan, building on efforts of presidents before them, really did quite a bit of deregulation of the traditional type of regulated industries, so the airlines, trucking, rails, et cetera. So it's a very interesting time that I think we can maybe learn from and think about today. But there was obviously something else going on that accounts for the increase in the Federal Register pages, and that is a lot of new regulatory agencies. Now, these agencies that were created during that period were unlike the previous regulatory agencies, which focused on rates and entry into different industries. These tended to be more cross-cutting and were concerned with health, safety, and environmental issues. And they were done by mostly executive branch agencies as opposed to independent regulatory commissions that operated through formal rulemaking and adjudicatory hearings. And what I think is interesting about this is that the approach to this type of regulation was very different when economists and people analyzed it. It wasn't, the old type of regulation was pretty clearly harming consumers to the benefit of the regulated industries. This new type, it was less clear, and the focus was more on how can we make it better, how can we do it more efficiently, more cost effectively. And so it was as a result of this rapid increase in regulatory activity that presidents, starting with President Carter, started issuing guidelines to agencies saying, before you regulate, understand what the benefits and what the costs of the regulations are likely to be. And after you've regulated, look back to see what the benefits and costs of the existing regulations are. So President Carter started this with his executive order in 1978. And then in 1981, actually I should back up, in 1980, Carter also signed the Paperwork Reduction Act, which created this office, the Office of Information and Regulatory Affairs, or OIRA, as Judge Barron mentioned. President Reagan was actually the one to set that office up in early 1981, and he gave it not only responsibility for reducing paperwork, which is what President Carter had signed, the Paperwork Reduction Act, but also to review regulations. And this time he said, I want you to look at the benefits and costs and maximize the net benefits. Choose an alternative that is the one that is the best, recognizing that there are some benefits and costs that are hard to measure. He also gave OIRA the responsibility for reviewing the actions of executive branch agencies to ensure that they did just that. So you had this first, when Judge Barron talked about you've got the three branches overseeing the regulatory activity, President Reagan really established in the Executive Office of the President an office that would keep tabs on his regulatory agencies. President Clinton, in 1993, rescinded that order after several months, but he replaced it with an order that was essentially the same. He changed some of the procedures, but he kept in place both OIRA's role for reviewing significant regulatory actions and the requirement that agencies should be regulating only when there's a compelling public need and that the benefits of the regulatory activity exceed the costs. That executive order is still in place today, so it survived President George W. Bush, President Obama, and it is still in place with President Trump today. Now, President Obama issued two executive orders that reinforced and added to President Clinton's executive order, but none of them either changed OIRA's responsibility for that review or changed that core goal, which is this net benefit test. Which brings us to President Trump. In his first couple months in office, he issued two very important regulatory executive orders. The first one, and we heard about them both from the White House counsel last night, John McGahn. The first one said for every new regulation, identify two to remove and make sure that you offset the costs of new regulations by modifying or removing existing regulations. The second one created regulatory reform offices in each agency to monitor that and to try to do just that. I think this is significant both in that it maintains the existing executive order. So he doesn't say, I don't want you to consider benefits anymore. He says you still need to consider benefits and costs, but now you have a budget to operate within. The other thing I should mention, and you can tell I'm a creature of the executive branch, is that Congress was doing some things during this period, but not nearly as significant or hasn't exercised the same level of control. There were some statutes, acts passed that, including the Paperwork Reduction Act, the Congressional Review Act, which we've seen used this year. And the courts have also been involved. You've had, in this window, you've got Chevron deference, which if I've had students, so I'm in the public policy school, students who've had some law might mention that when I show them that run-up in regulatory activity. Then you have the American Trucking Administration, the River Keepers, and the Michigan EPA. All of those have gradually moved more towards how important it is to do this benefit cost analysis. So I think that's where I'll stop my history and turn things over.
Okay, thank you, Susan.
Good morning, everybody. As Judge Barron mentioned, I will discuss the connection between some of the policy questions that Susan has discussed over the last few minutes and the Constitution's framework of separated powers. So the entire issue of how the president may control the executive branch and the regulatory state occurs against the backdrop of one of the most consequential constitutional questions of all time: whether the president has the authority to remove, or to be more colloquial about it, to fire subordinate officers within the executive branch. From the very first days of Congress, through the impeachment trial of Andrew Johnson following the Civil War, through the presidencies of Woodrow Wilson and Franklin Roosevelt, through the enactment and then the failure to reauthorize the independent counsel statute, both Congress and the courts have addressed this question, which goes to the very heart of how the constitutional structure functions. And if you think about it, the primary reason is control. Without the ability to remove subordinates, the president lacks the authority to control the executive branch, and one of the primary tensions in defining the Constitution's president is who should control: the president, who has some degree of democratic accountability, or the Congress, which also has some degree of democratic accountability, though perhaps far more diffuse and dispersed, or perhaps control should be lodged in members of the government who lack democratic accountability, but who have some degree of expertise in the substantive areas that are at issue. Article 2, Section 1 of the Constitution says, "The executive power shall be vested in a President of the United States of America." And you can compare that language with Article 1, Section 1 of the Constitution, which lodges legislative powers herein granted to the Congress of the United States. And the fundamental constitutional question that's at stake here is whether this textual difference, the use of herein granted in one provision and not in the other, has important practical consequences. That's because, unlike Article 1, which then proceeds to enumerate the powers of Congress, the remainder of Article 2 contains no comparably extensive, exhaustive list about presidential powers, and certainly makes no reference to removal as such. So this textual difference was the basis of the first significant constitutional debate in Congress after the Constitution was adopted, during what's known as the decision of 1789. Members of the House of Representatives, they debated, while considering a bill to create a new Department of Foreign Affairs, the means of removing or terminating executive officers. Some representatives argued that Article 2, in granting the executive power to the president, also vested him with a power to remove executive officers, because that's an inherently executive function. Others argued that, hey, the Senate's consent is necessary to appoint officials, so its consent should also be necessary to remove those officials. And still others argued the Constitution is silent on this topic, so Congress can do what it wants. Finally, there was even a small band of congressmen who argued that the only way to get rid of executive officers was through impeachment. James Madison, he was at this debate as a representative from the state of Virginia, and he argued that the Constitution, quote, affirms that the executive power shall be vested in the president. He further argued that other portions of Article 2 carve out exceptions to the executive power, such as the Senate's participation in the power of appointment. And that meant that Congress could create no further exceptions to those exceptions already specified. As he put it, in this regard, Congress has, quote, no right to diminish or modify the president's executive authority. The end result is that the congressman concluded that the Foreign Affairs Act presupposed that the Constitution granted the president a power to remove subordinate executive officers without expressly granting that power. Fast forward 100-odd years, and the two most significant decisions by the Supreme Court in this area are Myers versus United States, which was decided in 1926, and Humphrey's Executor versus United States, decided 9 years later. In Myers, the court held that the Constitution confers on the president the authority to remove subordinate officers within the executive branch, and thus a statutory provision that requires the consent of the Senate before removal of certain postmasters was unconstitutional. Much like the first Congress in 1789, and the court in the Myers decision refers to that debate that occurred in 1789 extensively. The court, in an opinion by Chief Justice Taft, who was himself a former president, held that removal was an inherently executive power which the Constitution vests in the president. In Humphrey's Executor, which, as I mentioned, was just 9 years later, the court held that the holding in Myers is limited and that the president could remove subordinate officers within the executive branch, but that holding does not apply to officers who wield what the court described as quasi-judicial or quasi-legislative powers. So according to the court, the commissioners of the Federal Trade Commission fell in this category, and the provision that restricted the president's authority to remove those commissioners was lawful. That provision required the president to show some sort of good cause before removal occurred, and good cause was further defined to only apply when the president shows that there's some sort of neglect of duty or inefficiency or malfeasance in office. This distinction between the Myers case and the Humphrey's Executor case, it frames the entire question of presidential control of the executive branch. Because in light of these decisions, Congress created a variety of so-called independent agencies, and their independence rests on the notion that the president can only remove their heads for cause, for the reasons that are stated in the statute. And the two resulting and significant legal questions for any OIRA administrator, and so I'm going to segue into the conversation that we're just about to have, are as follows. First, most congressional statutes, they vest in the head of an agency or his or her subordinate discretion to act in a certain domain. For example, head of agency regulates such and such issue in the public interest. And the question is, does that conferral of that discretion mean that the individual who's specified in the statute exercise the discretion? Or can the president remove, and the removal authority, does it imply that there's a power to control subordinates by directing them to exercise their discretion in a particular fashion? And second, the second big question is, does the president's power to direct subordinates apply to independent as well as executive branch agencies? That question, I'll just say, breaks down into two subcomponents. And the first is, are the restrictions on removal of independent agency heads, are they constitutional? And second, assuming that they are constitutional, does failure to conform to the regulatory budgeting of the OIRA administrator constitute good cause within the meaning of the statutory provisions restricting removal? So these are two very deep questions. Rather than resolve them, I'll just step back for the moment and allow my co-panelists to share their thoughts on OIRA generally. Thanks very much.
All right, then. I'll just say bluntly, my basic position, the president has too much power. The president has effectively seized that power through executive orders requiring White House review and approval of major agency rules. I want to illustrate the basic problems with this framework through one example. The example comes from 2011 from the administration of President Barack Obama. In 2011, President Obama directed the Environmental Protection Agency's administrator, Lisa Jackson, to withdraw a revised air quality standard for ozone. As reasons for requiring the EPA administrator to withdraw, that is not to publish that standard, President Obama cited regulatory burdens and regulatory uncertainty, particularly, he said, as our economy continues to recover. The revised standard for ozone had been under consideration at the EPA and at the White House for the entire length at that time of President Obama's administration. It had been through a new round of notice and comment, and it had been through an extra and intensive scientific review within the Environmental Protection Agency. And so what do I see wrong with this situation in which this agency rule, which had been sent to the White House for approval, becomes subject to a directive from the president to not to go forward with that rule? I think the basic point that's wrong with this situation is actually law, and it's statutory law. The Clean Air Act gives authority to the EPA administrator, not to the president, to issue air quality standards. The Clean Air Act also provides that air quality standards are to be based on the scientific evidence of harms to human health and welfare. They are not to be based on concerns about economics or feasibility. And this came to us not only, I think, from the text of the Clean Air Act itself, but also from unanimous ruling in a case called American Trucking versus Whitman, in which Justice Scalia wrote for the court that the Clean Air Act does not permit considerations of economics and technical feasibility to factor into setting these air quality standards. So what does this mean for law? To me, it means that under the Clean Air Act, the president is not the right person to decide what air quality standards should be, and that economics and feasibility are the wrong factors to consider on that statute, under that statute. So to me, there's a basic legal problem with the president countermanding the EPA administrator on this point. He's the wrong person to decide, and he used the wrong factors in making that decision. So I think this point, this is my one specific example, but I think the point is generalizable beyond the Clean Air Act. White House review and approval of agency rules puts the wrong people in charge of deciding whether a rule will issue and on what grounds, and it encourages consideration of extra statutory factors, factors that have nothing to do with the decision-making framework that the statute sets forth. Under this framework, White House review of agency rules, the statutory delegations of decision-making authority to particular people in particular agencies simply do not matter, and the statutory enumeration of particular factors as relevant to the agency's decision do not matter. Moreover, the statutorily prescribed process for establishing agency rules doesn't matter either. So when the White House reviews agency rules and when the president declares the authority to countermand the agency's decisions about the matters charged, the agency is charged with deciding, the notice and comment period that is required for rulemaking under the Administrative Procedure Act and under statutes like the Clean Air Act simply becomes a charade. We ask for the public's comments, say thank you very much for your submission, and then it's open to the president to countermand the decisions the agencies would make in light of the evidence and in light of those comments for reasons that have nothing to do with the statutory charge. The president can simply swoop in at the last minute and order a particular outcome. And then the problem, to my mind, is deepened by the fact that then the agency is left to explain the outcome on the basis of reasons that were not the real reasons for the agency's choice, or the agency's result, I should say. So the one thing I would say in favor of the example I've given is that at least that decision on ozone was transparent. That is, at least that decision the president made publicly and explicitly and said, you may not issue this rule. That's usually actually not really true. In fact, most people don't even know what OIRA is. I don't think most people know that the White House is effectively in charge of approving major rules. In most cases, the White House's rejection of agency rules is not explained in a so-called return letter, which gives the agency the rule back and tells it either not to go forward with it or to revise the rule. So that, in other words, the ozone decision, as problematic as I think it was, at least had the virtue of transparency. Most of the rules rejected by the White House don't have that virtue. And for me, I will say that my position on this point is not dependent on who's in office. I've actually been worried about presidential power over the administrative agencies through the administration of President Clinton when I came to be an academic, and then the administration of George W. Bush, and then Barack Obama, and now I'm worried about it under Donald Trump. That is, I think one can be worried about the extent of presidential power no matter what one's political philosophy or regulatory philosophy is. And that, I have to ask you all just to ponder a question, which is, I take it, one of the things I actually admire about the Federalist Society is your concern with concentrated power and its effects on people's liberty. And so I wonder why, and maybe I'm wrong about to the extent to which you champion the framework I've criticized, but why do you champion this framework when it allows such concentrated power in one person without regard to law? Thanks.
Hi, good morning. I sense I'm in trouble here because I have Susan Dudley, who's a former OIRA administrator, and they're always keeping an eye on me in my current role. And I've heard now from Lisa, who thinks that everything I'm doing is violating a statute. So, but you know, I guess I get to bring up the rear here. So. Of course, as the OIRA administrator, in part, it's my role to provide a more muscular defense of presidential control of administration. And I just want to explain a little bit about why that type of control helps further the rule of law and can, in many instances, also promote individual liberty. So through this process of centralized review that we undertake at OIRA, my office really serves as one of the principal mechanisms of presidential control of administrative agencies. And I admit I'm familiar with Lisa's work, you know, and her comments here, you know, reflect much of her scholarship. But I have to be honest, I thought in some ways it's quite well settled that really across the political spectrum, that at least some form of presidential administration is not only lawful, but also desirable. So, you know, you think over the past, I don't know, 10 or 20 years, it's a view that's been expressed by Professor Cass Sunstein. It's a view expressed in a very lengthy article by now Justice Elena Kagan. And of course, it's a view that's been taken by many theorists of the unitary executive at the Federalist Society, such as Gary Lawson and Stephen Calabrese. And I think that the fact that there is so much consensus on the framework, even if not on the particular applications, rests on certain basic ideas about presidential control. Right, first, of course, we have the constitutional structure of the unitary executive. I think presidential control can also provide an important form of democratic accountability. And in practice, having more White House control also provides a certain level of consistency across the government in terms of how regulatory policies are implemented. And in fact, I think some of the advantages of presidential control are so far acknowledged that even the American Bar Association and the Administrative Conference of the United States have been advocating for a number of years that there should be a OIRA review of even the regulatory actions of independent agencies. So I guess despite, though, I think these widespread views, I know that there is still, you know, concerns about presidential control and power. So I just thought I would discuss a little bit about some of the high-level principles about why presidential control is important and how OIRA can work to implement that. So, I'm currently an administrator, but I was a law professor, and so I like to begin with the Constitution because I taught constitutional law for many years. You start with Article 2, right? Article 2 vests all of the executive power in the president. And in my view, that makes him not only the commander-in-chief, it also makes him, in many ways, the administrator-in-chief. And the text and structure of Article 2 support this conclusion. Right? The president has the appointment power. I think he has the removal power. There is the opinion in writing clause, which allows the president to seek an opinion in writing from the heads of departments. The president has an obligation to take care that the laws be faithfully executed. And those are just a few of the ways in which the text and the structure of the Constitution place the president in control of administration. He chooses his advisors, and they report up through the chain of command to him. And so, in my view, even when a statute confers regulatory authority, say, on the head of an agency, the president may direct and control the execution of that authority. So another point in favor of presidential control, right, is that the president within the executive branch is the only democratically accountable official, right? And so if elections are to have consequences, regulatory policy should also reflect presidential priorities. And where the execution of the laws leaves discretion, that discretion should be exercised consistent with the president's views. Now, in many cases, agencies have no specific requirement to regulate at all. And the regulatory choices they're allowed to make can be within a really wide range of discretion. So I think a reasonable question then is, who should be exercising that discretion? Right? Why would an agency official with no democratic accountability exercise political discretion about whether to regulate at all and how to regulate? And so insofar it's consistent with law, administrative discretion should be directed and controlled by politically accountable actors. So, and in that vein, my office, OIRA, is really an important vehicle for ensuring this type of presidential control as well as accountability. OIRA has this long-standing function of centralized regulatory review. And the way that works in practice, I know sometimes what we do is not always apparent. Agencies send us their rules, and they cannot finalize a rule until our review is complete and we agree on the substance of a rule. And so what do we do in this review process? Well, we ensure a number of checks, and these are principles that have existed for a long time. They're clearly articulated in the executive order that Susan mentioned, that was written by President Clinton. But at the outset at OIRA, we want to make sure that regulations are consistent with the law. It's our view that agencies don't have any kind of free-floating regulatory authority. And so if they're going to act, we want them to indicate quite clearly what their statutory authority is or where their authority comes from. Sometimes it may be a judicial decision or requirement. And we want agencies to really take the best interpretation of their statutory authority, and that means also acting with respect for the non-delegation principle and not exceeding the authority that they have. And I think that's a very important check that we can play. OIRA also, we look to see whether a rule is lawful, but even if an agency has authority, I think there's still another really important question, which is this rule necessary, right? Does this rule serve some broader public purpose? Is it going to help the American people? Has there been, for instance, a substantial market failure? Otherwise, perhaps it's better to let individuals and businesses exercise their own judgment. And OIRA in part does this, through cost-benefit analysis and ensuring that rules have substantial net benefits. Another way that OIRA can ensure presidential control is that we coordinate regulatory policy within the executive office of the president. So we are working every day with other components of the White House, the different policy councils, to think through regulatory policy. And we also oversee a process of interagency review, which ensures that issues are fleshed out from a number of different perspectives. And I think that this role is appropriate because if you takes seriously that the president has an obligation to ensure that the laws are faithfully executed includes all of the laws. And the OIRA process, in part, helps to ensure that the execution of the laws fits together as a whole. And it can prevent the kind of tunnel vision that might occur within a single agency that's driven by a very particular mission. So, for instance, if the EPA would like to issue some type of rule, it may implicate important issues to the Department of Energy or Agriculture or Transportation. And so there needs to be some coordination on those regulatory issues to prevent duplication or inconsistency and in general, the excessive accumulation of regulatory burdens. So there are often trade-offs, and there's often a difficult balance that has to be taken between different interests, because Congress provides a number of different statutory mandates, and it's in part the duty of the executive to make those operate in a consistent manner. So I guess that's something in part about the general role of my office. I just wanted to say a little bit about what we've been doing in particular in this administration. So one of our major initiatives has been working with agencies on the president's agenda of reducing regulatory burdens. We are implementing the goals that he set out in his executive orders to eliminate 2 regulations for each new one and to implement a regulatory budget. And we're going to be releasing the fall regulatory agenda in a couple of weeks, and I think you'll see that we have far exceeded the goals that the president has set out. We're going to be at much more than 2 regulations out for each regulation that's been promulgated, and the agencies government-wide have substantially reduced regulatory costs. So I'm hoping Susan's chart will look very different next year. So we are really undertaking a coordinated effort to reconsider rules that are excessively burdensome or duplicative or inconsistent. And we're also going after sub-regulatory documents such as guidance, enforcement manuals, FAQs, and the like. And as Don McGann mentioned yesterday, we are working with agencies to very strongly enforce norms of fair notice and due process. So from my perspective, I really consider the president's regulatory reform efforts as fundamentally about restoring accountability and promoting a more constitutional government. And we believe that fewer regulatory burdens can mean more individual liberty. Right? Reducing regulatory requirements and the massive obligations that we're masquerading as guidance will leave people with more freedom. Right? It will make it easier to find a job. It will make it easier to start and maintain a small business. And in some instances, it will leave people freer to follow their conscience. And regulatory reform can really promote economic growth and innovation, and those may be 2 of the biggest drivers of individual freedom. So the administration really takes these principles seriously, and they're being they're being reflected in our regulatory policy and our regulatory choices, which I think is a form of presidential control in practice. So I'm out of time, and I have some answers to the questions that were posed by my other panelists, but I'll leave that for the discussion. Thank you.
Thank you, each of you, for setting the table for us. And you need a little bit of tension in the panel for it to work. So thank you, Lisa, for suggesting that 2 of the panelists shouldn't have their jobs. What I thought I'd start with would be Susan, because the way you described OIRA's role was focused solely on the idea of a relatively technical role of cost-benefit analysis. And by the time we heard from Naomi, the role of OIRA sounded, to me at least, somewhat different than a purely technical analytic role, really enforcing the president's priorities and ensuring that he was carrying out his legal function, that the laws be faithfully executed. Those are 2 very different ways of thinking about OIRA, and that tension's built right into the executive order as to the functions of OIRA. So maybe, Susan, just from your perspective, has the role of OIRA, as you observed it, changed over time in that way, or is those those maybe competing or distinct missions always been part of OIRA's function?
That's a great question. Am I on? That's a great question. I think OIRA has always worn several hats because it has always had the executive order guidelines, which is kind of this green eye shade look at regulations to make sure that they, well, all the things that I talked about earlier. But then they're also part of the executive office of the president. And the OIRA staff, it's a career staff, they're very aware of that. And they realize that sometimes there may be some tension between those two goals, between implementing the President of the United States, who is elected by the people of the United States, implementing his priorities and following this green eye shade approach. What I do find, and I bet Naomi will agree with me, those are in tension much less than you would think. So it was it was not that. Yes. Anyway, maybe another, if I could add just a little something to that. Economists have been concerned with President Trump's executive orders because they say benefit cost analysis is the best way to look at regulations, and you're adding this budget constraint, and that's only going to make regulations worse because we can't issue regulations that have net benefits. And to respond to that, I would paraphrase James Madison and say that if regulators were angels, benefit cost analysis would be sufficient. In fact, I'm sure that was in his first draft of Federalist 51. But they're not. So they have, all the political economy reasons why, and Naomi mentioned tunnel vision, all these reasons, regulators, there's a lot of judgment involved in benefit cost analysis, and that's why I think adding this budget constraint is similar to what we do in the fiscal budget. That we would never say to agencies, you do a benefit cost analysis of your programs and we'll give you all the money you want. You're spending other people's money, and therefore some kind of a budget constraint makes sense. And Jimmy Carter actually recognized that in 1980.
Maybe I'll go to Aditya because you left us with a good question and then you sat down. So maybe I'll make you answer the question about how to think about Lisa's point regarding just the legality of what enterprise OIRA is engaged in, but what any overseer, could be the president directly, could be White House counsel, you could think of a number of actors who might be charged with this function. And maybe just to set up the question, I noticed Naomi said that in thinking about the constitutional question, you start with Article 2. But you might have thought you'd start with Article 1, which does, after all, come before Article 2. And the thinking that I think is driving Lisa's argument, if I understand it, is Article 1 is reflected in the statutory command to the agencies, which sets the limits of what they can or can't do. So how can it be that the president could be directing them to do something that might be in tension with their statutory mandate?
Sure, yeah. So as I see it, there are two parts to the argument that the president cannot direct. One is a policy aspect, and that is that the executive branch agency is in a better position to answer this question than the president. The second is about legality, and that's what Lisa's comments were focused on and your question asks, which is, if there's a statute and it says something along the lines of the Secretary of such and such, the Secretary of Treasury shall promulgate regulations to address the public interests in this and this domain, does that mean that the Secretary of Treasury, him or herself, must exercise that discretion? That's basically the question that's posed. And so if the president tells the Secretary of Treasury, hey, I think you should take into account costs and benefits in this particular way, is that somehow unlawful? My view is no. And the reason is that those types of statutes are enacted against the backdrop of settled congressional understandings. Just how do those statutes work? And so to take another example, that statute under settled understandings presupposes that the Secretary of the Treasury could delegate within the Department of the Treasury to some other official to exercise discretion. And so we don't ordinarily assume that the Secretary of the Treasury, him or herself, must use the discretion. We assume it's just the backdrop of how to understand that provision, that other officials within the Department of the Treasury could use the discretion. And the understanding that the president would be able to direct the secretary as well, it's once again a backdrop against which Congress legislates. So that's actually less of a constitutional argument. It's more of an implied congressional intent argument that when Congress enacts these statutes, they have this view that the president will be directing, the secretary might be subdelegating.
So, and just to push the limits of that, suppose we have an agency head who says no to the president. On your view, I take it you don't think the president can go ahead and issue the rule in his own name.
That makes sense. That makes sense. That's
So
exactly
the
right.
recourse of the president in that circumstance would be just to fire the agency head and get some new agency head who would then do what the president wants? Is that the idea?
That is the idea, yes. So one could say that this is an implied congressional intent style argument that occurs against the backdrop of the removal power.
So Lisa, just on your account of it, given that there is a presidential removal power, what's the practical significance of the observation you make? Because in reality, we don't observe agency heads being fired with a high degree of frequency for refusing to do what the president wants. And so in the reality of this, given the backdrop that removal is a possibility, for at least for the agency heads who are not independent agencies, how does it actually function, aside from how we might describe it at sort of an abstract level of law?
I think it would mean that the president would need to be selective about which battles to fight and would need to take political heat for actually firing somebody for making a decision he didn't agree with. It wouldn't be this systemic review of agency rules, constant oversight by officials, many of them career officials at OIRA, over the agency's work. And so, yeah, sure, the president could fire an agency head for issuing a rule the president didn't like or for having policies and priorities that were different from the president's. But to me, that's a very different setting than this systematized practice of requiring White House approval before the agency acts. Can I say one word
Absolutely.
about the congressional backdrop? This is, everybody always says when I make the points that I've made, people say, but Justice Kagan but Cass Sunstein. And yes, there are many progressives who have, and many progressive presidents who have liked presidential control. I don't think it's a surprise that presidents like presidential control. And yet, and Justice Kagan's point is that we should interpret statutes that delegate authority to an executive agency as giving the president the authority to make those decisions, that that's a fair presumption across statutes. And I just think that's bonkers, actually. I don't understand. We haven't had presidential control over agency rules in the way that we have it now until people count it differently, either Carter, Reagan, fairly recently. Many, many statutes were passed without an understanding of this kind of systemic review of agency rules. And so I don't think it's fair to say we can presume that Congress thought that the president would be exercising the kind of oversight that the president now exercises. I'll just give you one concrete example of my reason for my skepticism about this presumption about congressional intent. The Clean Water Act was passed in the early 1970s. I think the vote was unanimous or close to unanimous in Congress, but President Nixon vetoed the Clean Water Act, and then the Congress overrode the veto. And what the presumption would suggest is that we should assume that President Nixon, that Congress thought President Nixon, who vetoed the statute, actually should have authority to figure out what the agency's rules should be. And that just doesn't seem right to me. And I think that's true of an awful lot of statutes. Once you look at specific statutes to see whether the presumption makes sense, it just doesn't. And so if we're thinking on statutory grounds, I don't think that we should believe that the OIRA review is well-founded.
Naomi?
Yeah, sure. Yeah, I think those are interesting points. I think in part, one of the questions that occurs when a statute confers authority on an agency head, that I think is important because, as you mentioned, Judge, that means the president can't actually issue the rule himself. I think that's an important limitation, right? Congress has given that power to one of the agency heads. But I think then the question about how much the president can direct or control what the agency head does is not really a question of congressional intent. It's really a question of the Article 2 power, right? Because the president, is vested with all of the executive power, and in the course of executing the laws, needs to have the ability to, especially in areas where there are discretion, to control what his subordinates are doing. So I think even if Congress intended for that decision to somehow be made purely separately by the secretary of an agency, I'm not sure that that would be consistent with the structure of the Constitution if a president were to choose to control that discretion. And I would also just add that it's often very hard to do this. As was mentioned, the removal power is very rarely exercised, although there is always a threat of it. So I think agency heads do often operate with a reasonable degree of autonomy because the removal power is such a blunt tool and so difficult for the president to, in fact, exercise. So I think in practice, when Congress gives that authority to an agency head, the reality is that they have a fair amount of discretion there.
So Naomi, does that mean that, in your view, the independent agencies are no different than the non-independent agencies with respect to OIRA control?
Yes, that is my view.
But formally, the executive order still distinguishes between the two?
The executive order currently does not include the independent agencies, right?
Yeah.
Right. But I've written about this in my previous life, but I think the independent agencies execute the law. The Supreme Court has said that they are part of the executive branch, and so it is in some ways hard to understand why they would not be under the control and direction of the president.
So maybe, Aditya, I'll come back to you because I realize that in answering the question, you kind of dodged the question in the sense because you nicely framed it as a question of statutory interpretation. But if I'm hearing Naomi, that's not really quite how she may be viewing where the source of the control comes from. And I guess if you take Lisa's point and you say, do we really think that the Congress that passed these statutes intended for the discretion that's conferred to be exercised by the president in office? Lisa says, why would we necessarily think that's what the Congress intended? Naomi's then saying, but who cares whether they intended or not? Article 2 just gives the president the authority to exercise control over that discretion. How would you evaluate that?
So I think that's a difficult question when, in fact, there's a discretionary authority that's vested within a subordinate executive branch officer, and it's made clear somehow that the president, by statute, does not have the authority to direct that. I wonder whether one way to look at it is that the officer ought to exercise the discretion, and the president ought to be able to say, well, if it's not exercised in the following way, I have the authority to remove you. So it's the removal power that's the check in those instances. And that's why I suppose I do want to push back on the notion that this implied congressional intent argument is incorrect, or the implied congressional intent is not, in fact, the intent that Congress does truly have. Because I think this debate has occurred over the course of the nation's history, and there are early opinions of the Attorney General that address this question, which is about when discretion is vested in executive branch officers, what in fact does Congress intend? Do they mean for those officers to be exercising the discretion without presidential oversight?
Maybe before we open it up to questions from the audience, I'll just close with Susan. And you're fortunately not a lawyer, but you ran OIRA. And I'm just curious whether, practically speaking, this discussion about where legal authority resides matters, as you understood it, in the sense that there's actual human beings in OIRA, and there are actual human beings in the agencies, and they're in some negotiation interaction with one another. And just from your experience, what is the mechanism, the actual practical mechanism by which OIRA is able to exercise control over the agencies?
I think there actually was consideration both at the beginning of the Clinton administration and the beginning of the Obama administration, because there is concern over OIRA. Should we get rid of OIRA? And they realized that if we did, we would have to create another entity that does the same thing, because the president individually cannot monitor everything that's going on in the agencies. And so, yes, I think there is that sense that it's an important function. And one of the advantages that OIRA has, I think each of these presidents realized, is that it's transparent. You could have, and it has that cross-cutting view. So from a policy perspective, I think it does perform that function for the president that the president needs. Just to go back to my slides, the oversight that presidents have applied have coincided with that growth in these executive branch agencies and the administrative state. It may not have been needed before 1970 because there just weren't that many regulations.
Okay, thank you. Well, let's open it up for people who have questions. And obviously, if the panelists have additional points you want to make, you can, in the guise of answering a question, make one of those points or ask a question to a fellow panelist.
Gary Lawson's getting up.
Go ahead.
Sure. Richard Belzer, long time ago, an OIRA economist, long enough ago that I referred to OIRA as they and not we. But I think it took a decade before I was able to do that. For Professor Hines, a clarifying question and then the real substantive one. The clarifying question is, with regard to the NACs, if I understand you correctly, the right thing to have done in that situation would be for the president to have allowed the administrator to either resign or be fired. Those are the only options that would be permissible if the statutory authority vested, the administrator is left alone. But related to that now, if you're going to give serious credence to statutory authority, we keep forgetting that OIRA was created to implement the Paperwork Reduction Act, and in that Congress gave the OIRA administrator extraordinarily broad authority to regulate paperwork. And so it has the authority to disapprove hundreds, thousands perhaps, information collections every year. It reviews thousands a year and disapproves a handful. And it largely rubber stamps all those things, but it has that authority granted by Congress. So would you be perfectly supportive of that authority being exercised by OIRA, perhaps in lieu of the executive order process? But clearly it's been delegated to OIRA, and there's no appeal. There's no administrative appeal, and there's no judicial review.
Yeah, on the first question, I think that is the choice. I think the choice is the president can fire the agency head, but the president shouldn't be directing the agency head to come to particular decisions. On the second point about the Paperwork Reduction Act, I don't think anything in the Paperwork Reduction Act gives the OIRA the authority to review major rules for consistency with cost-benefit analysis.
No, it reviews information collection requests. That's what the Paperwork Reduction Act is about, not rules. But it has then the authority to disapprove them extensively, and that is okay.
Yeah, I think that would be a sneaky way to achieve what OIRA now achieves. I would find that problematic. So you're suggesting just fitting OIRA review into that statutory structure by expanding it.
Lisa, let me just ask you a question before we take the next question from over here. We don't observe agencies resisting. Is that true? I mean, that's your experience, right?
You don't observe it, but it happens.
So just say a little bit, that's what I'm trying, just explain a little bit, since from your own experience, how does this dynamic work out? Because, you know, having worked myself in an agency, the Department of Justice, it's not as if every agency's position is to sing the praises of the White House all day long. So there is this tension, and how does it manifest itself from your own observations?
It was really interesting. I started working in the Obama administration on the very first day of the Obama administration. And at that time, President Obama, right around that time, had issued a memorandum saying that he was rethinking the process of OIRA review, all up and down, all the way through. So cost-benefit analysis, the relationship of agencies to the White House, and so forth. This was met with great happiness in the Environmental Protection Agency, which, as you may be aware, is one of the most beloved objects of OIRA's attention.
And so well
Right. And in fact, I would place some of the uptick in the need for White House review in the passage from 1970 to 1980. All of our basic federal statutes on the environment were passed, and that's been a major target. But and then when President Obama didn't actually change this review, but arguably in some ways deepened it, it was a matter of great controversy within the agency, and the idea that the agency would hold on, for example, its program on climate rules to wait for the time when the White House would be ready to receive those rules or ready to hear the message about climate and the importance of acting on climate, just seemed really fundamentally to be a problem at the agency. So that it's just one agency, but it is an agency that's been particularly in the crosshairs of this process. And you may not see public resistance because that would be taken to be not on, both by political appointees and career level civil servants. But there is a great deal of consternation in that agency about this process.
Thank you so much. Elon Werman with the Stanford Constitutional Law Center. Thank you, first of all, for a really terrific panel. I wanted to ask a question about sort of the nature of the powers that we're discussing here, because a lot of the premise of what we've heard in this conference and other panels is that really the problem with the modern administrative state is that it exercises unlawfully delegated legislative power. So when Professor Heinzeling, you talk about what the EPA is doing here, isn't it really exercising legislative power in a sense when it sets these ozone standards? Or if not legislative power, then at least a power that's not strictly and exclusively executive in the sense of being enforced against private individuals. So maybe it's like a blended power. It partakes of both legislative and executive qualities. And if that's true, and maybe it's not, but if that's true, then does the Constitution really so clearly specify what kind of relationship the president has to have to the officials exercising that kind of blended power or partly legislative power? In other words, if it's not really executive power, but I know our doctrine presumes that it is the Article 2 answer of removing these officials really so clear, at least with respect to the exercise of that kind of power?
Well, the irony is I think that I'm more in favor of controls on agencies than you guys are in a way. And I actually think that agencies should be controlled by the statutes that give them their charge. And on the constitutional point, that's just not the law today. And I understand that there's hope, right, that it may change, but it's not the law. And so that the position I take, I think, would be to have agencies actually really tightly adhere to their own statutory authorities.
Can I just,
Yeah, go ahead.
Oh, yeah. So, yeah, I just have one thought about that, which is if what the agencies are doing is not exercising executive power, then I guess it's not an Article 2 problem, but it's an Article 1 problem, and then it's not a question about presidential control, it's a question about whether they should be acting in the first place. So I think that's a much more fundamental problem. If you think they're not exercising executive power, I don't think that means there shouldn't be presidential control. I think there's perhaps a different answer in that case.
Well, keeping the string going, I have another question for Lisa. And it's a perfect segue because it really is, you know, in the independent agency, which I've been such a great victim of, has also the luxury of having the judicial branch taken out of it because you can't really involve them, as they've made many rulings in my case, until they're finished with their process. So who's supposed to oversee it if not the executive branch? And the judicial branch has been sort of nullified until you've walked through years of fire and millions. The legislative branch is not, I mean, law isn't oversight. And the founders made the legislative branch intentionally difficult to get things through. So how would your proposition actually function as any sense of oversight, other than concentrated power?
I would go back to Judge Barron's point at the outset, that it's not just the president who exercises oversight authority over the agencies. It's Congress. Congress can exercise that. Congress can actually change the statutes if it thinks that there's too much power in the agency or the wrong kind of power. They don't like you to point that out to them. If you go and testify on the Hill and say, you guys actually have the power to change this, that is not cool for Congress, members of Congress
That's sort of
to
my
say
point.
that. Right? That's the system we have.
Susan, I want to just ask you about an assumption that sometimes comes up in these conversations about OIRA, which probably has to do with the history of OIRA and presidential control, is the assumption that the president would be a checking force on regulatory action. But in principle, if from the principle of executive control or presidential control, there's no reason why that has to be the case. And of course, in then Professor Kagan, now Justice Kagan's article, many of the examples of presidential administration and directives that she gives are prompts to regulate, as opposed to checks on regulation. And just from your own account of the history of this, maybe I'll ask Aditya whether the constitutional issue changes at all if we're thinking about the president restricting an agency from acting versus prompting or requiring an agency to issue a rule. Has there been any directional shift in the role of OIRA and presidential control with respect to what agencies do?
I think generally what you'll see is that OIRA is more of its job tends to be more constraining the agency, and it's again gets back to this tunnel vision notion. Agencies don't need the OMB budget side to say, you're not asking for enough money for your programs, here, take more money. They generally don't need OMB to say, you're not regulating enough, here, you should regulate more. That doesn't mean that it hasn't happened. There are cases of prompts, but I think in general, OIRA steps back and has this cross-cutting vision, and that's the one thing I think we haven't talked enough about. It coordinates across agencies too, so that if EPA does its work in a vacuum, only working with its committees in Congress, there's no one to say that the Department of Interior or Energy or Agriculture are doing something that will conflict and overlap and complicate things and make it not work. It's a very important function, and having that cross-cutting perspective tends to make OIRA say, we understand that priority, but there are dozens of other priorities, therefore, let's see if we can do it more cost-effectively.
Aditya, does the particular action the president's taking, whether he's prompting versus checking, make any difference legally as you see it?
As I see it, it should not. And the way to think about it, and I'm in complete agreement with Lisa on this point, is that Congress enacts a statute, and the obligation of the executive branch is to comply with the statutory mandate. Here we're talking about whether the use, to the degree there's any discretion in the statutory mandate, the use of that discretion ought to be accomplished by one person within the executive branch, the president, or another, perhaps the agency head to which delegation, the authority has been delegated. And it doesn't seem to me to make any difference to the degree that there is some discretion that's been delegated, whether it's a prompt or a prohibition.
Go ahead.
I want to thank Lisa for being here. You are obviously the most popular panelist for the questioners. Two-part question for you. First of all, in your comments, you said that as a result of this OIRA process, quite often there are improper criteria injected into the rulemaking process. On that, let me just put aside the inherently illogical American trucking decision for a moment and just ask you, in light of the Entergy versus Riverkeeper decision and Michigan versus EPA, isn't it quite clear that the agencies have wide discretion to use benefit cost balancing to do more good than harm when they implement their statutes? That's question one. And two is, I assume your concern with this process is you're afraid the president is going to do more harm than good and somehow undermine what's in the interest of societal well-being. But if you think that's the case, why don't you support a statutory cost-benefit mandate that would override any political or economic rent-seeking and require that all regulation does more good than harm?
Okay. On the improper criteria, I don't agree with Entergy so much. I don't think Entergy goes nearly as far as Michigan versus EPA in pressing us towards cost-benefit analysis, but I agree with you that Michigan versus EPA could, and in the lower courts has begun to require more comparing of costs and benefits. I agree with that. As you may not be surprised to hear, I think the decision in Michigan versus EPA was misguided. And I think that we're going to be dealing with the consequences of that case for some time. The word appropriate was the central word in that case. It appears 10,000 times, more than 10,000 times in the US Code. And if we need to adjust our view of the word appropriate all those times, it seems to me that the decision was highly, a kind of aggressive decision. But I agree with you. It does change to some extent the legal landscape. And on the president doing more harm than good, I simply don't agree that cost-benefit analysis is the only way of figuring out whether a rule is going to do more harm than good. And if I had to choose, I would prefer a legislative directive to that effect to a presidential directive. I just prefer that to happen, but I don't. There's only one environmental statute, for example, just one. Out of all the statutes we have, there's one environmental statute that provides for formal cost-benefit analysis, and those are amendments to the Safe Drinking Water Act. And yet we have all of this cost-benefit analysis being used to reject agency rules under the environmental statutes, even though that's not the criterion. So yeah, I would prefer it if Congress, if we're going to do it, I'd rather have it under a legislative
Just quickly,
mandate.
how about a statute that just said all agencies must do more good than harm when they issue regulations, period? Would you support that?
A cross-cutting, and that would be their sole, doesn't that, are you supporting that as a matter of non-delegation? Isn't this your goodness and nice
would
commission,
support it,
Professor
but
Lawson?
Gary, you want to come and jump in? You must be getting nervous.
It's
I think
supplemental
statutes take place in particular contexts and try to solve particular problems. And so, and take place in a particular political environment. And so it's not easy to say what will constitute more good than harm in advance of dealing with a problem in a particular context. So sure, I'd like statutes to do more good than harm, but I don't think that means cost-benefit analysis necessarily.
Professor Henseling,
We find someone else to start with.
yeah, right.
Someone else?
And,
This is why I love coming to the Federalist Society
or this-
conventions. I feel so special.
This certainly picks up on what Naomi said. It strikes me you make.
So a question for Naomi. Great.
Yeah. It strikes me though that a great and challenging case has been made regarding textual fidelity to the statutes, and that you have laid that correctly at our feet. The concern is that I think that that to further that argument in this context, you ask for a much more abstract understanding of the constitutional powers, and I think that's a tension that has emerged. And is that something that you acknowledge? Do you treat the Constitution not as textually and more abstractly?
I wouldn't put it that way. I would put it that I have carefully hedged on the constitutional question in these remarks. And I think I have good company in Justice Kagan. Now I'll rely on her. And so, the idea that I don't find the unitary executive theory appealing. But you could be in favor of this kind of centralized review without that, and you could think about it in terms of its legality under statutes, and I think that's what Justice Kagan's point is in her article, Presidential Administration. I just happen not to agree with the presumption she creates.
And I meant that as a question of delegation as well. You almost seem to come to our side a bit on that you would prefer to see some of this really accomplished by Congress, clearly. You're challenging us because it hasn't been, but our concerns about delegation remain.
I'd absolutely prefer to have Congress do a lot of this. That is their power. That's their job.
Another noted hedger, Gary Lawson.
Right. I mean, Professor Goodness and Niceness from Boston University. And in fact, given my pension, I mean, my question is actually going to be for Susan Dudley when I'm done. But given my penchant for moderate, middle of the road consensus positions, let me first see if I can get all the panelists to hold hands here, because I'm actually thinking that they all agree. Professor Einzerling has to be right, at least to some extent. If a statute says don't do X, you can't do X. The agency can't do X. Even under the strongest theory of the unitary executive, the president can't do X. The president and the agency can't do X. The president and the agency and the Jacksonville Jaguars defense can't do X. It says you can't do X, you can't do X. End of story. On the other hand, if we're talking only about what Professor Bamzai was mentioning a moment ago, and that is purely non-statutorily prescribed discretion. Presumably the president could call up the agency head and say, do what I say or you're fired. Well, then why couldn't the president call up the agency head and say, do what Naomi Rao says or you're fired? In which case, everybody is right depending upon what the statute says. And instead of making global judgments about the OIRA process, good, bad, legal, illegal, depends on the statute. And if the statute says you can't think about costs and benefits, you can't think about costs and benefits, and maybe everybody's actually agreeing. The actual question was actually to Susan Dudley, and when you had that wonderful chart up there about pages in the Federal Register, the huge spike comes not just after new agencies are created, but also after a new APA is created by the lower federal courts. The whole mishmash of, I mean, if you're in 1963 and you're an agency issuing a notice of proposed rulemaking and a statement of basis and purpose, it's like 3 paragraphs long. If you're an agency in 1973, you now, under the then current doctrine, have to write PhD theses at several different stages. And indeed, the pages you had up there wildly understate, because there's incorporation by reference of warehouses full of documents that they just didn't make the government printing office pay. So I'm just wondering how much of the spike that you see has to do with the newer forms of judicial review post-1970 rather than any other trends that are involved.
I don't know the answer to that. I mean, you're right that it's not a perfect metric, and one of the things it does is it includes the preamble to the proposal, which isn't the actual code. But we also do see the U.S. code increasing over that period. And that might be it's another slide I slap up there sometimes.
Yes, Craig Richardson from Omaha. I'm an executive of a large publicly traded corporation that's regulated by no fewer than 12 agencies directly. And this really is a question for Administrator Rao and Professor Dudley. Would you agree with me that there's been far too little attention given to the cumulative impacts of multi-agency action? This is really more than coherence and consistency, but all about the cumulative impacts of the next idea from an array of agencies at the margin. And second, would you agree with me that there's a growing body of evidence that in many cases regulatory goals can be best achieved using performance-based approaches that allow for decentralized and idiosyncratic implementation rather than command and control?
I'm not sure. I may have missed the second part of that. So is there a preference for performance-based over command and control?
Right. So when an agency considers, having concluded that some sort of regulatory action is necessary, shouldn't there be a preference, a stretch to find a performance-based approach? And oh, by the way, in both of those questions, how best to do that and where to locate it?
Go ahead, Naomi.
Yeah, sure. Yeah, I do think in many instances a performance-based standard is probably better. It part depends on the statutory authority, it depends on the situation, but I think that's certainly true. And I agree, I think in the past there has not been probably enough focus on the cumulative regulatory burdens, but I really do think President Trump, I mean, with his really ambitious executive orders, that's what he was trying to get at, not just trimming regulations around the edges, but, kind of taking a weed whacker to them. And in part, that's what's happening. So I think we're very aware of that problem, and it's a blunt problem in some ways. But we're doing that, but we are also doing the things that Susan talked about. I mean, the technocratic work of OIRA continues apace, right? We're looking at costs and benefits and doing all of the ordinary OIRA functions, both for regulatory actions and deregulatory actions. But we are concerned with this bigger picture question of the sort of the growth and accumulation of burdens.
Susan, did you want to say something?
I'll agree with Naomi and just emphasize that cumulative burden, which really is important, you can't do that without an entity like Naomi's, without OIRA. It has to be some agency that has that cross-cutting look, because individual agencies cannot understand the cumulative burden that all the different agencies of the government are applying on this poor individual.
Maybe this last point is worth generalizing a bit, because several years back, as many of you probably recall, there was a lot of discussion of czars, which were various people in the White House who were assigned to various agencies to oversee them. That's outside the OIRA structure. And of course, there's many, many actors in the White House other than OIRA who are overseeing what agencies do. And it just picks up on the point that Lisa made, which is presidential control and cost-benefit analysis need not be the same thing. It's a particular way of reviewing agency action, and there's even been some literature which suggests that there sometimes is a big disconnect between White House priority and OIRA priority, that those don't necessarily mean the same thing. And the way OIRA is constructed with a kind of professional bureaucracy of its own, at least there's been some literature suggesting you have a bureaucracy on top of a bureaucracy. You still don't actually have anything like a president overseeing it. That's more likely to come from elsewhere. I'm just wondering how each of you think about that problem, maybe starting with Lisa, since no one's asked you a question in the last 35 seconds. Just from your experience, I mean, how do all these other actors play into this beyond OIRA?
Mysteriously. I mean, it's true. When I was at EPA, we always wondered why was a rule stalled, and it was really hard to figure out why a rule was stalled and who was in charge of figuring out whether that rule would shake loose from the White House. And I came to understand more deeply what was happening when Cass Sunstein wrote his book after his time in the White House, and talked about the process of OIRA review, and it involves a cast of thousands sometimes. That's what it appeared to me, that it's people from the other agencies who might be career staffers or might be the heads of agencies, people within the White House who might be the chief of staff or might be the national economic advisor. People, and the way Sunstein put it in a speech after he served at OIRA was to say that the reason a rule gets stalled at OIRA is because somebody who matters, that's a quote, somebody who matters had a problem with the rule. And that just seems chaotic to me and just increases the odds that the consideration will include extra statutory factors. When you have people who are not charged with implementing a statute, but who are playing on the promulgation of a particular rule, it just seems to me that it increases the possibility of illegality.
Naomi, do you want to comment on that, or do you not want to comment on that?
I mean, I think I can comment on it a little bit in general terms. You know, there are, of course, a number of different actors within the White House, right? And they represent different perspectives, you know, whether it's about domestic policy or economic policy or legal concerns in the counsel's office. And I think it's in some ways appropriate for them all to be weighing in on regulatory policy because, of course, the president doesn't have just one thing he's trying to maximize, right? He's really trying to look at regulatory policy from a big picture. And I think one way that happens is by allowing some of the close advisors to weigh in on what type of regulatory policy is pursued. And that's, of course, subject to what Gary said, right? Which is the first thing is that it has to be consistent with law, right? So we're only talking about the discretion within a particular statutory framework. We're not talking about going outside of the law, but where there is space in the law, how is that going to be exercised? And so, you know, it might be in some ways opaque, but I think that's just, you know, it's just part of the nature of the process.
Go ahead, Susan.
Can I just make a quick, I think Naomi's right, and that is going to be the case whether you have a OIRA or not. There are always going to be people who are special assistants in the White House who are going to be interested in regulation. That's where at least that's where tons of a large percentage of policy gets made. So what OIRA does is it makes it less opaque. You have an OIRA administrator who can testify before Congress. You have, when OIRA sends a rule back, which I think only happened once in the Obama administration, but I sent several rules back. It's with a very clear letter that says why. I think you're never going to get away from people in the White House wanting to be involved in regulations. They always will. You can't stop it. What OIRA does is it coordinates it and it makes it more transparent.
Aditya, do you want to just comment a little bit about how, if we take the point of agreement that Professor Lawson was trying to coax out of this panel, that everybody's got to follow the statute.
Right.
And then you take Lisa's point, and which I think just has to be true, there's all these people in the White House who are interested in the regulatory product weighing in, and not all of them are probably super focused on what does the statute say. There's at least a likelihood that, or a possibility, that the regulatory product is going to be affected by some consideration by somebody who mattered, who didn't have first and foremost in their mind what the statutory requirement was. From a constitutional perspective, what are we to do with that fact? Is that proof that actually the statute can't actually be as controlling as we thought it was? Is that proof that, I mean, what follows from that seeming reality?
Right. Well, so for starters, I mean, there ought not to be any shading of the statute, but understandably, human beings, one can imagine that under some circumstances there could be. And it seems to me that the reason why, if there is, you would want that type of decision-making to be conducted at the presidential level rather than at the agency level goes to some of the remarks that I made at the very beginning of the panel, which is that there are two different sort of policy interests at stake here. There's the democratic accountability that the president has. So to the extent that the president, through these directives, is not complying with statutes, then there's a check through the democratic process on that exercise of discretion, as opposed to less of a check, at least at the agency level. I think I completely agree with the way that Professor Lawson put the point of agreement on among the members of the panel. The one point of disagreement, then, one that perhaps we haven't discussed as much, is the scope of the president's authority to oversee independent agencies, because there you would get into a question about restrictions on removal, about which I'm sure there is disagreement among the members of the panel.
You want to say a little bit about
it? Oh, well, so I agree with Naomi on this point, and that is that the OIRA administrator has the same authority to issue a regulatory budget for independent agencies as she does for other agencies.
Do you want to say anything about that, Lisa, or no?
Oh, you know what, well, let's...
Okay, great. Go ahead.
Yes, Alden Abbott Heritage Foundation. Actually, a question, I think, for Susan, Dudley, and Naomi. President Obama's amendment to the executive order emphasized qualitative factors being included in cost-benefit analysis, including such things as values related to income, redistribution, so on. Some economists might say, well, this is really totally open-ended, and it allows one to find net benefits on any rule, depending upon how you weigh these vague qualitative factors. Is any thought being given to perhaps revising or removing those qualitative factors? And if not, what's your view, Naomi, on how they should be applied? And maybe Susan could jump in as well.
I mean, you know, I think with cost-benefit analysis, in some ways, it's not always a perfect science, right? And there will be qualitative concerns that are taken into effect, right? What those precisely are, or what type of weight they're given, how they're measured or discussed, I think is different for each rule, right? And you know, maybe in this administration we're concerned with qualitative interests such as individual liberty, right, and deregulatory rules. You know, the Obama administration had a different set of qualitative criteria. So, you know, I think it's hard to take them out entirely, but I think we want to, if we want rules that really substantially maximize net benefits, we want to try to quantify things as much as possible. So I think that's still our goal.
Yeah, I agree with that. I think benefit cost analysis is not and should not be the only measure by which we measure regulations. You have to start first by, should the government be here in the first place? I mean, that's the individual liberty arguments that Naomi makes. And those things are all, what President Obama added was already in the executive orders, that there are some things that can't be measured, and that's true and that's fine. What it really should be is just a transparent accounting of what we know, the way Paul Noe put it, of the good and the harm that a regulation does. And let's make sure we're doing more good than harm.
Hi, my name is Lawrence Kogan, and
You'd be just a little louder.
my name is Lawrence Kogan. I use my litigator voice, and I have an equal opportunity question for anybody on the panel. And I do want to take notice of the technocratic statutory approach taken to the review of the regulations that OIRA undertakes. Beyond cost benefit, obviously, there's also information quality. And information quality goes to the credibility of the information, technical and scientific, that an agency disseminates to the public, and its impact on the population. So we have to then look at the constitutional and the political ramifications. I, for one, do not have faith that Congress will ever legislate properly again because of the broad delegations and holes in the statutes that it already has legislated. Clean Water Act is a perfect example of an overkill situation, which through its 1977 amendments, people have argued have gone beyond what the intent of cleaning the water up was at that point in history. Now, because we have international exchange of legislators, judiciary, and executives from different agencies, my concern is that not only does the president manage the bureaucracy efficiently through the review of regulations that are coming forth from the dependent and independent agencies, but also where Congress hasn't been politically accountable in exercise of its Article 1 power, the president can, in his or her exercise of the Article 2 power, be politically accountable by not only looking at the statutory mandate, which is rather broad in most statutes, but also in reviewing not just the Article 1 vis-a-vis Article 2 relationship, but the Article 2 relationship to the Bill of Rights. Doesn't the president have an obligation under the Constitution to represent all the people within this country as citizens and anyone who voted, to make sure that if a regulation is issued by an agency, not only is a cost-benefit analysis undertaken to ensure net benefit versus net cost, in addition to take into account the quality of the information that is being disseminated by the agency, especially in the scientific and technical realm, but also that when he or she takes that all into account, the Bill of Rights are preserved, property is sanctified.
Naomi and Lisa, maybe you want to each. Or Lisa,
I'm
you want to?
struck. Well, I'm sorry. I thought you nodded to me.
Yeah.
I'm just so struck by the willingness to create non-statutory regimes that the president can just create. And if the president, now you're saying that the president not only may, but kind of must, constitutionally speaking, adjust statutory regimes that you find uncomfortable or inconvenient. And that strikes me as quite amazing.
Professor, is the Fifth Amendment uncomfortable or inconvenient for you?
No.
Okay, so why are you asking me that question?
There's a wide and fertile space between the Fifth Amendment and a lot of regulation.
There's statute. I mean, I've read Reading the Law by Justice Scalia. Okay, there is statutory anchoring here. But we're talking about the Constitution, which supersedes all statutory law. So why wouldn't the president, in exercise of Article 2...
I just don't see anything in the Fifth Amendment, forgive me, but that requires cost-benefit analysis.
Well, when you look at the jurisprudence...
And I think that would be an adventuresome constitutional
When you look at the
theory.
jurisprudence of the Fifth Amendment takings clause in the last 10, 15 years, it's a rich person's game. Most people cannot win that kind of lawsuit.
Why don't we move to this gentleman?
There's been some discussion about the president's authority
I think people aren't able to hear you.
I'm sorry. There's been some discussion, obviously, about the president's authority to oversee independent agencies as opposed to cabinet agencies, departments. And I'm not advocating a specific aspect of it, but I'm curious as to the panel's opinion as to whether the independent nomenclature is not so much the independence from executive authority as much as the agency was created because it does not fit specifically within an existing department, should not be part of a cabinet department, and perhaps isn't large enough to encompass its own department and have other functions below it. So it's solely an independent agency because it's independent from a department and not independent from executive authority.
Aditya, you want to help us get some understanding of what is an independent agency as a legal matter?
I think the questioner flags an important point, which is just something that's confusing about the way Congress sometimes enacts statutes, and that is that Congress will designate certain agencies to be independent without actually providing for-cause removal restriction within the statute. And those agencies are not truly independent in the sense that the president does, in fact, direct and control them and can remove the officers who man them for any or no reason at will. So that's just ambiguity in the statute in the sense of the term independent. When I use the word independent agency, what I refer to is not that type of independent agency, but one in which there is some sort of statutory provision that says that the president can only remove for certain reasons.
Great. Well, I think we have time just for these two questions, if you're relatively brief.
I'll try to be quick. This question is for Naomi. What do we do about counter-majoritarian agencies? So we have the obscene situation now where we have at the Consumer Product Safety Commission, my old agency, a majority of Democrats still on that agency issuing rules that are presumably rules that the administration wouldn't agree with. That doesn't seem democratic in any way, shape, or form. How can we get a handle on that kind of counter-majoritarian agency?
Yeah, I think that's a real problem. I think one of the reasons that some of these multi-member commissions are constitutional is because the president, by statute, controls the balance of power, right? If they have a full slate of commissioners, the president appoints the chairman and controls the majority of commissioners. So what happens, when there's sort of a rump commission, which has happened to a number of agencies where there have been vacancies? I guess part of that goes to their independence, right? Can those commissioners be removed by the president? It's a problem of getting nominees confirmed quickly, right? But I think it's those sort of rump commissions just suggest, I think, another problem with the model of having agencies that are independent of any executive control.
Last question.
Great. Kevin Stack, I teach at Vanderbilt. This is a question for Professor Bamzai and maybe for Administrator Rao. And I'm trying to pick up on the conciliatory note that Professor Lawson initiated and maybe see how much further it would go. So I think everyone on the panel suggests that say if a statute delegates authority to issue rules to a secretary, the secretary has to be the one that issues them. The president can't, in his own name or in her own name, issue the rules. And doesn't that suggest the statute vets the discretion over how to implement the authorities granted in the secretary? So it really decides the question of whose discretion it is, right? The president then, and the role of OIRA is to convince the secretary that under the statutory authority granted to that secretary, that this is how it should be implemented. And if there's a failure of convincing, well, then there can be a moment of removal. But I guess I want to suggest how much does, once you concede that the secretary is the one that has to issue the regulations formally, doesn't that also decide the question of whose discretion it is?
So I'm not sure I would concede that, and then the reason why is that we interpret those statutes, and to take the easier part of the interpretive issue, we interpret those statutes to allow the secretary to say, someone within my department, you exercise the discretion on my behalf, and then I will formally promulgate the regulations.
Isn't that usually pursuant to a statutory authority to delegate?
Not always, but it can be in the sense that there are in fact statutes, or there used to be the view that statutes that authorize only a particular individual to exercise authority require that individual to exercise the discretion. But we now operate under a backdrop in which statutory provisions that vest discretion can be delegated. So I take that to show that the statutes can't be read in isolation. They should be read against the backdrop of the entire statutory framework and whatever other presumptions are being made by Congress. And I think that in light of those types of presumptions, a reasonable one is one that the president has the authority to direct within the scope of discretion.
I want to just thank all the panelists for such an interesting conversation. Thank you.